For millions of lawful permanent residents across the United States, becoming an American citizen represents the final chapter of a long and emotional journey. It is the moment many immigrants dream about for years, sometimes decades. People work hard, pay taxes, raise families, build businesses, follow the law, and contribute to their communities with the hope that one day they will stand in front of the American flag, take the oath of allegiance, and officially become citizens of the country they now call home. But for a growing number of green card holders, that dream is turning into something they never expected. Instead of receiving an approval notice after filing Form N-400 for naturalization, they are receiving terrifying letters from USCIS questioning whether their green card should have been approved in the first place. Imagine opening your mailbox expecting progress toward citizenship only to discover that the government is now reviewing your entire immigration history and suggesting that your lawful permanent residence may never have been valid. For many people, that moment feels like the ground disappears beneath them. Fear, confusion, panic, and uncertainty take over instantly. Families begin asking difficult questions. Could citizenship really be denied after all these years? Could a green card be challenged a decade later? Could someone actually end up in immigration court after applying for naturalization? These are not theoretical questions anymore. Across the country, immigration attorneys are seeing more cases where USCIS officers are revisiting old applications during the naturalization process and looking much deeper into how a person originally received permanent residency. What many immigrants do not realize is that filing Form N-400 opens the door to a complete review of their immigration history. USCIS does not simply check whether you have lived in the United States for the required number of years or whether you pass the English and civics tests. The agency examines everything connected to your immigration record. Officers review your first entry into the United States, every visa you ever held, every application filed on your behalf, every statement made to immigration authorities, and every document connected to your green card approval. This comprehensive review is authorized under the Immigration and Nationality Act, which requires applicants for naturalization to prove they were lawfully admitted for permanent residence in the first place. That legal phrase sounds simple, but it carries enormous consequences. If USCIS concludes that your green card was obtained improperly because of fraud, misrepresentation, ineligibility, procedural errors, or undisclosed immigration violations, they can deny your citizenship application and, in certain cases, refer you to removal proceedings before an immigration judge. That possibility is what makes this issue so serious and so emotionally devastating for many lawful permanent residents who believed their immigration history was already settled years ago. One of the most common situations that triggers this kind of scrutiny involves marriage-based green cards. USCIS pays extremely close attention to marriage cases because marriage fraud has long been a major enforcement priority for immigration authorities. Even if a couple has been married for many years, USCIS officers reviewing an N-400 application can revisit the original marriage petition and analyze whether the relationship appeared genuine at the time the green card was approved. Officers may compare old applications, interview notes, addresses, financial records, tax returns, and previous statements looking for inconsistencies. Sometimes a small discrepancy from years ago suddenly becomes the center of attention during the naturalization interview. Applicants are often shocked because they assume the approval of the green card permanently resolved those issues. Unfortunately, that is not always the case. Immigration law allows USCIS to re-examine prior approvals if there are concerns about fraud or eligibility. For immigrants who received conditional green cards through marriage, the scrutiny can become even more intense if there were complications involving the I-751 petition to remove conditions. Missing documents, inconsistencies, prior separations, or poorly prepared filings can all become red flags during naturalization review. Another major area of concern involves immigration violations that may have occurred before the green card was granted. Under federal immigration law, there are many grounds of inadmissibility that can prevent someone from legally obtaining permanent residency. These include unlawful presence, prior deportation orders, criminal history, visa fraud, unauthorized employment in certain circumstances, and false claims to United States citizenship. In some cases, people may have qualified for waivers that legally forgave these issues, but if USCIS later believes the violations were not properly disclosed or addressed, officers may determine that the original green card approval was legally defective. This is especially frightening because some immigrants may not even fully understand the details of what was filed on their behalf years earlier by consultants, preparers, or even attorneys. There are individuals who signed immigration forms without carefully reviewing every answer, trusting someone else to handle the process. Years later, during naturalization, USCIS may identify inconsistencies between old applications and current statements, triggering accusations of willful misrepresentation or fraud. Even mistakes that occurred decades ago can suddenly become critically important once a person applies for citizenship. Over the past several years, immigration attorneys and advocacy organizations have warned about increased scrutiny during the naturalization process. Reports from legal organizations and immigration practitioners suggest that USCIS officers are conducting more extensive reviews of applicants' immigration histories than in previous years. This shift has become especially noticeable in the current enforcement environment, where federal agencies have emphasized stricter vetting procedures and enhanced information sharing between USCIS, Immigration and Customs Enforcement, and other agencies within the Department of Homeland Security. As a result, naturalization interviews are no longer viewed by many attorneys as simple final steps towards citizenship. Instead, they are often treated as high-stakes reviews of a person's entire immigration journey. This does not mean every applicant should panic or avoid filing for citizenship. Millions of naturalization applications continue to be approved successfully. However, it does mean that applicants should approach the process with caution, preparation, and a complete understanding of their immigration history before submitting Form N-400. During the naturalization interview itself, USCIS officers have broad authority to ask detailed questions about an applicant's background. Some interviews proceed quickly and smoothly, while others become lengthy examinations involving prior marriages, employment records, overseas travel, old visa applications, or previous immigration encounters. If an officer discovers information that raises concerns, several things may happen. USCIS may issue a request for evidence asking the applicant to provide additional documentation. The agency may also issue a notice of intent to deny, commonly called a NOID, which gives the applicant an opportunity to respond to the government's concerns before a final decision is made. In the most serious situations, USCIS can deny the naturalization application outright and issue a notice to appear, placing the individual into removal proceedings before an immigration judge. Hearing the words removal proceedings terrifies many immigrants because they immediately fear deportation. However, it is important to understand that receiving a notice to appear does not automatically mean someone will be deported. It means the government has initiated a legal process where an immigration judge will independently review the case. The individual has the right to present evidence, challenge the government's claims, and seek relief if eligible. Still, this is an extremely serious situation that requires experienced legal representation immediately. One of the biggest mistakes immigrants make when facing USCIS scrutiny is trying to handle complex legal issues alone. Immigration law is extraordinarily technical, and small mistakes can have enormous consequences. If you receive a request for evidence, a notice of intent to deny, or any indication that USCIS is questioning your green card history, it is critical to speak with a qualified immigration attorney as soon as possible. An attorney can review your immigration file, identify potential risks, gather supporting evidence, prepare legal arguments, and help you respond strategically rather than emotionally. Attorney-client privilege also allows you to discuss sensitive aspects of your history confidentially. Many people fear telling a lawyer about mistakes from the past, but withholding information from your own attorney only increases the danger. The more honestly and completely an attorney understands your history, the better they can protect you. Preparation is one of the most powerful tools available to green card holders considering naturalization. Before filing Form N-400, immigrants should carefully review their immigration records, including prior visa applications, adjustment of status paperwork, travel history, employment records, tax returns, and any interactions with immigration authorities. Applicants who obtain green cards through marriage should gather evidence demonstrating the authenticity of the relationship, including joint bank accounts, leases, photographs, insurance records, children's birth certificates, and tax filings. Employment-based applicants should collect employment verification letters, labor certification documents if applicable, and records confirming compliance with the terms of the original petition. The goal is not to panic but to prepare proactively in case USCIS requests additional evidence or raises questions during the interview process. Consider the story of a woman named Maria, a lawful permanent resident who had lived in the United States for more than 10 years before applying for citizenship. Maria originally entered the country on a student visa and later married a United States citizen. She successfully adjusted status, received a green card, built a stable life, and eventually felt ready to become a citizen. During her naturalization interview, however, the USCIS officer noticed discrepancies between statements made on an old visa application and information contained in her adjustment paperwork. Suddenly, what Maria expected to be a routine citizenship interview turned into an intense examination of her immigration history. USCIS issued a notice of intent to deny questioning whether her green card had been lawfully granted. Maria was devastated and terrified that she could lose everything she had built. Fortunately, with the help of an experienced immigration attorney, she gathered substantial evidence supporting the legitimacy of her marriage and provided documentation explaining the discrepancies in her earlier records. After months of stress, legal preparation, and additional review, USCIS ultimately approved her naturalization application. Maria's experience illustrates an important reality about the immigration system today. Preparation, documentation, honesty, and legal guidance can make an enormous difference when complications arise. The current immigration environment has also contributed to increased anxiety among green card holders. Since 2025, federal immigration agencies have emphasized stronger enforcement measures, expanded background reviews, and more rigorous screening procedures for immigration benefits. News reports have discussed enhanced vetting initiatives and greater coordination between agencies responsible for immigration enforcement and adjudication. Whether these policies continue, expand, or change in the future, the reality for applicants today is that immigration records are being examined very carefully. This means immigrants should avoid relying on assumptions or outdated advice from friends, social media, or unqualified consultants. Every immigration case is unique, and what worked for one person may not work for another. The safest approach is to verify information through official government sources and consult professionals who understand the complexities of immigration law. For anyone currently preparing to file for naturalization, the most important message is this: do not let fear paralyze you, but do not approach the process carelessly either. Citizenship remains achievable for millions of lawful permanent residents who qualify under the law. However, applying for naturalization is not simply a paperwork formality. It is a legal process involving a detailed review of your immigration history and personal background. If there are concerns in your case, identifying and addressing them before filing can be far safer than discovering them unexpectedly during a USCIS interview. Review your records carefully. Understand how your green card was obtained. Confirm that all prior immigration filings were accurate and complete. Gather supporting documentation. And if there is anything in your history that worries you, speak with a qualified immigration attorney before moving forward. Immigration law affects families, careers, financial stability, and futures. The consequences of mistakes can be life-changing, which is why education and preparation matter so much. USCIS policies can evolve. Enforcement priorities can shift, and procedures can change over time. Staying informed is one of the most important things immigrants can do to protect themselves and their loved ones. If you are already in the naturalization process and have received notices from USCIS raising concerns about your green card history, remember that you still have rights. You may have opportunities to respond, provide evidence, challenge findings, request hearings, or seek relief before an immigration judge. Do not ignore official notices, do not miss deadlines, and do not attempt to navigate serious immigration problems without professional guidance. At the end of the day, the dream of becoming a United States citizen remains alive for millions of immigrants who have worked tirelessly to build their lives in this country. But in today's immigration environment, knowledge, preparation, and caution are more important than ever before. Understanding how USCIS reviews naturalization applications, why certain green cards are being questioned, and what steps you can take to protect yourself could make all the difference in your immigration journey. Stay informed, stay organized, and never underestimate the importance of professional legal advice when dealing with matters that can affect your future and your family for years to come.